Justice I had announced at the beginning that...
Pete is yielding to me, and I will yield to Pete.
Okay.
Good morning.
Good morning, sir.
I want to begin with a few very simple and general propositions. I don't know if I'll ever drill down apart from these hypotheticals, but please just help me with these propositions. Do you agree that the voting rights laws should always be enforced in a race-neutral manner?
Yes, sir.
I certainly hope so, and I'm glad to hear that that's the department's position. So let me imagine a different administration. It would be a problem for the Civil Rights Division if any political appointee or supervising attorney expressed the view that the voting rights laws should never be enforced against blacks or other racial minorities.
I don't agree with that viewpoint.
It would be a problem for the division, too, wouldn't it? I'm glad you don't agree with it, but it would be a problem for the division.
That is not our practice. We look at facts. This is a
hypothetical,
yes.
Another administration. Would you agree it would be a problem if a senior supervising attorney or other political appointee expressed that view in the division?
Yes, sir.
Okay. If that person who held that view that we both disagree with was in a position to decide which cases to bring or maintain or continue, wouldn't it potentially taint their decision with regard to cases where blacks or other racial minorities were the defendants?
Fortunately, sir, we can continue to have hypothetical conversations. The good news is that in the division that we work in, if I could finish, sir.
No.
Well,
I really, since your time is so limited with us, since you've expressed your limited time, you know, these are just hypotheticals. This is another administration. I just want to know what the official policy would be.
I would prefer to speak with, I can speak to the policies and practices of the Obama administration under the leadership of Eric Holder. The Obama administration under the leadership of Eric Holder will enforce the laws, applying the facts to the laws, and we will follow the facts where the facts take us.
So
the leadership will so
what
reflect.
Is the answer to my question, which is, would it taint their decisions about whether to bring or maintain a lawsuit against black defendants if they believe the civil rights laws should never...
And we don't have people that are of that ilk, sir, so I guess it's a moot question, and the people who have been involved since January 20th in decision-making roles in the Civil Rights Division have been people for whom I have great respect. So we can have hypothetical conversations about other administrations, but I thought the focus here of this hearing today was to talk about the decision in the new Black Panther Party case. I'm prepared to talk about the decision in the new Black Panther Party case.
Would you be surprised then if one of your senior political appointees or a supervising attorney expressed such a view?
I'm quite confident, because I know the folks that work with me quite well, that they have been people who have applied the law, have called balls and strikes as they've seen them, and have done so to the best of their abilities.
That isn't an answer to my question. Would it surprise you if someone who was a supervising attorney or another political appointee in your division expressed such a view? Since that's not your policy, I mean, it would surprise me.
Yes, sir. Well, sir, I'm here to answer questions about the new Black Panther Party case. We can continue to have a dialogue about hypothetical people who are not in positions of leadership in the Obama Civil Rights Division. If that's the back and forth you'd like to have, that I thought I was here to talk about the new Black Panther Party case.
I think we are.
Okay, well, I'm happy to answer questions about the new Black Panther Party case.
Let me ask you, if someone came to you and said that someone in your division, I should say, came to you and said a supervising attorney or a political appointee made the statement that the voting rights laws should never be enforced against blacks or other racial minorities, you would investigate that report, wouldn't you?
I would take a look at the person who made the statement. I would take a look at the statement, and we would have a conversation about it.
You would want to interview the people who were supposedly present when that statement was made, wouldn't you?
Yes, sir.
And if you believed that statement was made, if you heard it, let's say, you would refute it, wouldn't you?
I would talk to all the people involved and figure out what the context of the statement is, and we would move forward from there.
But wouldn't you want to clarify to all the people who may have heard it that that is not the policy of the department and that you would not tolerate that kind of a policy?
Yes, sir.
Okay. At about, you helped the Obama transition team for your division, didn't you?
Yes, I did.
Okay.
Not just the division, the department.
Right, I thought so. But especially for you probably had special interest in the division. I don't know how long the clearance process is, but about the same month your nomination was put forward to head the division, there was a press report with specific instances, examples of people in your division, not all of them who are still there, who held the view that the voting rights law should never be enforced against blacks and other racial minorities. Did you take any?
If you have questions about people who work in the division, I am happy to have those questions submitted to the division, and we will take a look at any questions you might have. I thought that the subject matter of this hearing was what we did in the new Black Panther Party case. I'm having difficulty understanding the nexus.
The problem is you're not allowing us to talk to the people we've subpoenaed, the people who might have such evidence.
Well, sir,
and this is very helpful to me, though, that you're clarifying for your division. You're I hope, correcting the perception that the press reports indicate that the civil rights law should not be applied to racism. So to me, this is very valuable testimony.
Well, I'm glad that you think it's valuable.
I hope that everyone in your division is made aware of it. And I'll yield my time at this time, but for the next round.
Commissioner Yockey. Thank you very much, Assistant Attorney General, for being here today. I just want to follow up on some line that the prior commissioner was talking about. That has to do with the deliberate process privilege and how important that is. I mean, would you agree that in terms of the prosecutorial decision-making process, especially that the deliberate process privilege, there's a long-term interest in maintaining the integrity of the prosecutorial decision-making process, and that's part of why the deliberate process privilege exists?
Well, again, I want to be very precise about what
Sure.
I have said, because I have said that there has been a long-standing, again, and by long-standing I'm referring to, it has been a long-standing interest asserted in Republican and Democratic administrations, a long-standing confidentiality interest in not disclosing internal deliberations. And it's precisely grounded out of the fact that when you're prosecuting cases, you need to have, and again, when I refer to prosecuting, I'm referring to civil and criminal cases. If you're that frontline attorney, and I was that frontline attorney because I started in the division as a summer clerk, then I was a honors hire, then I was a first-line supervisor, and then I was the deputy AAG, and now I have the privilege of being the AAG. And regardless of where I was in that decision-making process, the currency of good decision-making is having the capacity to investigate the facts, have conversations with your supervisors, disagree, agree, sometimes disagree vociferously, but then come to a conclusion recognizing that we have a chain of command, we have career people who call balls and strikes, and that confidentiality interest has been an interest that has been well established,
Sure.
well respected, and that's why while we turned over 4,000 pages of documents, we continue to resist, not only here but elsewhere. When people want to talk to line attorneys and ask them, why did you do this, why did you do that, show me this about your memo, that is an interest that I have seen Republican administrations assert with the same vigor as Democratic administrations, and I think it's a good confidentiality interest.
So you would agree with this one Attorney General who said employees of the Department of Justice would likely be reluctant to express candidly their views and recommendations on controversial and sensitive matters if those views could be exposed to public scrutiny?